Punitive damages, liquidated damages, and penalties. As we have discussed, courts prefer to award money damages in expectation whenever possible. Expectation money damages are calculated by loss in value plus other loss, which includes consequential and incidental loss, minus loss avoided pursuant to the duty to mitigate damages, and limited by speculation and foreseeability. Specifically, in our conversation about efficient breach, we discuss why it is bad for society when courts punish parties for breaching an agreement. Sometimes society is better off when a party breaches, because then the property in question can be transferred or can be retained by a party who values it more. So long as the injured party is made whole by our measure of damages, gets the benefit of the bargain that they struck, gets what they expected, this generally produces an efficient outcome. Accordingly, courts do not generally award punitive damages for breach of contract. The second restatement of contract, section 355, says, punitive damages are not recoverable for breach of contract unless the conduct constituting the breach is also a tort for which punitive damages are recoverable. In other words, courts will not award more than expectation damages unless the breach was so aggravated that it constitutes a tort as well as a breach of contract. This is a course on contract law, not on tort law, so we will not discuss situations where the breach was done for cruel, malicious, tortuous reasons, as opposed to ordinary commercial reasons. For those cases, refer to the Restatement of Torts, such as the sections therein regarding intentional infliction of economic loss. Here we're talking about standard commercial parties who are not acting maliciously. So we understand that contract law does not punish such breaching parties, but instead seeks to put the non-breaching party in the position it would have enjoyed if the contract were performed. However, such damages can be hard to calculate. Parties may not want the uncertainty of a court deciding this formula. They may not want the court deciding how much one party must pay to the other in the event of breach. Instead, the parties themselves may specify how much one will pay to the other in the event of a breach. When parties specify in a contract how much one will pay to the other in the event of breach, this is called liquidated damages. Liquidated damages in a sales contract are effectively an option. They work like this. A seller can deliver a widget and receive X dollars from the buyer. That's performance of the contract. But if the contract has a liquidated damages provision, the seller can breach and pay Y dollars, the amount of liquidated damages, to the buyer. So the seller with a liquidated damages contract effectively has the option of performing and receiving compensation pursuant to the contract, or breaching and paying liquidated damages pursuant to the contract. The basic principle of freedom of contract says that courts should enforce such options. They're part of the basic economic bargain. But in fact, courts will not enforce a liquidated damages provision if it is unreasonably large. According to the second restatement of contract, section 356, an unreasonably large liquidated damage provision is considered a penalty. And penalties are unenforceable on the grounds of public policy. This is actually quite curious, because why would sophisticated parties in a commercial arm's-length transaction agree to liquidated damages or any provision in a contract that a judge should later determine is unreasonable? Isn't the fact that sophisticated and informed business parties agreed to a term at least pretty good evidence that they subjectively deemed it to be reasonable? Moreover, contracts often provide things like bonuses for early performance. Why would courts enforce bonuses for early performance but not quote-unquote penalties for late performance? Both bonuses and penalties are ways to encourage contract parties to perform. They're really symmetrical. So why enforce one and not the other? The restatement takes the counter position that penalties are not enforceable because they violate the purpose of contract damages. Contract damages are not supposed to be punitive, the restatement says. However, in my opinion, courts miss the point when they strike down liquidated damages provisions, because sophisticated parties at arm's length transactions are making a deal in which these liquidated damages are part and parcel of the bargain. You may be more willing to enter into an agreement with an unknown party if you know you'll be paid a certain amount if they fail to perform. And so this is one way that we might actually encourage lesser known parties to get invited to commercial bargains. However, since courts might not enforce liquidated damages, parties need to be careful about using them when creating a bargain. The restatement doesn't give particularly good guidance as to what constitutes a penalty. There's no set number or set formula, and that's another thing that always makes me a little concerned when judges determine what is not unreasonable, because how do parties enter into a contract with reasonable certainty about what will be set aside? The key thing to look out for is if the amount of liquidated damages is significant in relation to the contract price, it may constitute a penalty and courts may set it aside. And so if you are advocating for the breaching party and there is a liquidated damages provision, you may want to raise the argument that it constitutes an avoidable penalty that should be set aside and expectation damages rendered instead. Now that we have discussed the main elements of money damages, we know that expectation damages are the preferred remedy for a contract, and they're calculated as loss in value plus other loss minus loss avoided. Loss in value means the value the party would have received if the contract were performed, minus the value the party actually received. Other losses include incidental losses, which are costs incurred in a reasonable effort to avoid loss, and consequential losses, which include injury to person or property resulting from the defective performance. Loss avoided means costs that the party did not experience because of the breach, costs that would have been incurred but for the breach. And they include the duty to mitigate damages. We know that when damages are hard to calculate, courts may award restitution damages instead, putting a party back in a status quo position instead of giving them the benefit of the bargain. But courts will never award punitive damage unless the breach of contract is also a tort, and for this reason some courts are hesitant to award liquidated damages when in their judgment it amounts to an unreasonable penalty. Before we move from money damages to equitable remedies, are there any remaining questions about money damages at contract law?